Morning, Mr. Chairman, honorable members of the committee. It is truly an honor to be here today. I appreciate in the face of this weather event that you guys actually showed up here to do the people's business. I have the honor of representing over 5 million people nationally. I am the president of Convention of States Action. We are the national organization pushing forward for an Article 5 convention among the states. We have a fundamental problem in Washington, D.C., which is Washington, D.C. has grown out of control. I think Representative Taylor described it well, but I want to show you a visual representation. When we talk about the United States Constitution, we are generally talking about this document. Many of you have one of these. It's called a pocket constitution, this particular one from the Heritage Foundation. And I hear from our opponents all the time that this is just a wonderful, perfect document and we ought not to, quote unquote, mess with it. And I would agree with them on that. Unfortunately, today, if you call the government publishing office and say you'd like to order the United States Constitution, you'll be stunned because they'll ask you for $130+. Not because this one's printed on gold leaf, but because they are talking about this Constitution. And if you read the spine, I'm not overstating it. It says, the Constitution of the United States of America, Centennial Edition. 2,738 pages. This one's published in 2012. It's the last full edition. If you have all the supplements, I don't travel with those. It's over 3,000 pages and over 10 pounds. This contains every case ever issued by the United States Supreme Court telling us what this document means. And they have changed the meaning of this document dramatically and fundamentally and in a way that most Americans don't agree with. 72% of Americans today say that the federal government is too big and does too much. You can imagine at 72%, that's bipartisan. 80 to 85% of Americans polled over the last 30 years consistently say we need term limits in Washington, D.C. 80 to 85% of Americans polled consistently over the last 30 years say we need a balanced budget imposed on Washington, D.C. The three subject matter areas of the resolution before you today allow all of those things to be imposed on Washington, D.C. Why do we need to impose those things? Doesn't Congress have the power to propose those amendments? Indeed they do, and indeed they never will. It's not human nature for people to limit their own power. No tyranny in human history has ever limited their own power. This idea, the idea that you, the state legislators, would have the power to do this was presented to the Constitutional Convention on September 15, 1787. Colonel George Mason stood and he addressed the men assembled and he said this, we have a fundamental problem with the document we've drafted. By the way, this is only 2 days before the convention's over. They are done, essentially. The document is in final form. He says, we have a fundamental problem. We've given the power to Congress to propose amendments, but we've not given the same power to the people acting through the states. And he asked a question which I would ask you today. And I would ask the opponents of this resolution today. Are we so naive that we believe that a federal government that becomes a tyranny will ever propose the right kind of amendments to restrain that tyranny? Now, we know the founders' answers because it was very clear. Madison's notes reflect two abbreviations, two Latin abbreviations at that moment in the convention. And they say nin com, which is short Latin for no comment, no debate. They didn't even debate it. It was so obvious to the men assembled. I think they probably laughed when he said it. They felt foolish that they had forgotten to include this. And we actually know that because a vote was taken. And they included the second clause of Article 5, what we're actually debating today, unanimously. It's the only thing I'm aware of in the Constitution, no debate and unanimously adopted. And they chose to give you the power. Representative Taylor discussed this. I think this is incredible. When you come here and you get your orientation and they show you where the restrooms are and the cafeteria is, where the legislative drafting office is, they don't tell you about your federal power. I've asked this question to state legislators all over the country, people whom I respect highly. What's your role in the federal government? And I usually get a blank stare. And the answer is, you are the most powerful people in the federal government. For only you have the power to call a convention, to propose amendments, and to ratify those amendments, thereby changing the actual structure of the federal government. Why you? Why didn't they give that power to Congress? Why didn't they give that power to the president or to the courts? Sometimes the courts take it without being given. Why'd they give it to you? And the answer is because they were you. You are them. They were state legislators. They were on county councils and county boards of supervisors. They understood and believed in government close to the people. What we're asking you to do today is to restore federalism, to take a stand that South Carolinians should decide for themselves. The fundamental question that you have to ask yourself when you vote on this is who decides? Does Washington, D.C. decide for South Carolina? Do we believe that? Do we believe in the status quo? Do we believe that they should continue to control 60 to 65% of your budget like they do today? Or do you stand for South Carolinians who wish to decide for themselves? I have the honor standing here today of representing almost 40,000 South Carolinians who have signed the petition in support of Convention of States. And standing here speaking for them, I would ask you to pass this resolution out of subcommittee. I also have to let you know that today, sitting downstairs in the overflow rooms, over 60, when I was down there, over 60 people here in support, on a weather day like today, in support of Convention of States. An overwhelming number of people travel from all across the state to make their presence and their support known to you. So standing here today, it's my honor to represent those 40,000 South Carolinians, the South Carolinians who traveled here today, to ask you to pass this resolution out of subcommittee. Thank you very much. I appreciate your time today. Mr. Chairman, honorable members of the committee, thank you for allowing me to testify here today. It is truly an honor and pleasure. My name is Mark Meckler. I'm the president of Convention of States Action. We are the national organization with over 5 million members that are responsible for moving this initiative forward across the country. The reason that we're moving this initiative forward and have been doing so for almost 8 years now is that the United States government is at a crisis point. And it's not a crisis that has come on quickly, it's a crisis of generational proportions. If you look at all of American history, all the way to Washington's first administration, the federal government has grown under every single administration with the exception of President Calvin Coolidge. So virtually every administration in American history has grown the federal government. This is something that the founders feared, and they designed a government against this possibility. They were worried about overreach of the federal government. You heard it discussed how Colonel George Mason rose and added this second clause of Article 5 that we're discussing today to put into the Constitution the idea that the states would have to push back against federal tyranny. They knew, it was obvious, and it wasn't because they had a crystal ball, it was because they understood human nature. Centralized governments, strong central governments, always centralize more power. It is the history of humanity for this to be so, and it is no different in the United States of America. Today, we're facing a long-term debt of approximately $29 trillion. Really, if you look at structural debt, the things that are off the books, the unfunded mandates and unfunded liabilities, that is now over $157 trillion. No one knows how much money that is. But what we can all be sure of is that it is an immoral and unethical and unconscionable burden placed upon our children, our children's children, and our posterity. The founders said this. It's as true today as it was then. Today I come before you in support of a resolution that would have 3 subject matter areas be discussed at convention. First is anything that would propose term limits on federal officials. Second, anything that would impose fiscal restraints on government. And third is anything that would propose structure restraints, power and jurisdictional restraints on the federal government. I'd like to discuss each of those separately, if I might. I'd like to start with term limits. And you have essentially 2 term limits measures before you today. So I just wanted to make the distinction so that we can be a little bit clear here on what we're discussing. You have already passed a balanced budget resolution here in Wisconsin. We're now discussing a term limits resolution. Both of those are contained within SJR 8. So you have a chance to go to convention, discuss a balanced budget amendment, discuss term limits, and also discuss scope and jurisdictional limits. And I want to explain some of the differences in the term limits and why I think this is important. Generally speaking, as already testified to, the American people are fundamentally in support of term limits for members of Congress. We have broad experience with term limits in the United States. At least 23 states have term limits in place currently. There was an attempt to put term limits in place on the U.S. Congress. Unfortunately, the United States Supreme Court said we're not allowed to limit the terms of our congressional delegations. I say that with a bit of a smile because the Supreme Court has often overstepped its own jurisdiction and the reasonable bounds of the Constitution. I believe they did so in that case. We have that right and that ability. I think we should be very careful when imposing term limits, and we should do so in a structural way that also recognizes that there are other problems with people serving too long in the federal government. When you create term limits for people who are elected officials, but you do not also limit the terms of people who are staffers or bureaucrats, you empower what we've now commonly come to know as the deep state. In other words, if we turn over elected officials, but leave staffers and bureaucrats in place for 20 or 30 years, we empower staffers and bureaucrats. And by the way, also lobbyists. And so I'm concerned about term limits without also other limits on people who wield the power behind the scenes in Washington, D.C. So our term limits resolution is different than that proposed individually here in that it allows term limits for not just Congress, but for staffers, bureaucrats, and I think also importantly, the federal judiciary. All studies show that members of the federal judiciary, regardless of their political ideology or their jurisprudence when they enter the bench, the longer they're on the bench, the more they rule in favor of a wide and expansive federal government. And again, that makes sense. It's not evil, it's human nature in the sense that people who are part of a system that exercises expansive power, when they become part of that system and their pay is determined by that system, their staff is determined by that system, their power is determined by that system, they tend to favor that system. So I just wanted to make a distinction between the two types of term limits potentially proposed between these two resolutions. Second is imposing fiscal restraints on the federal government. This is fundamentally important. We just approved a $1.9 trillion spending package. Again, nobody in this room can even understand what 1.9 trillion is. It's actually, if you counted it in seconds, it's over 380,000 years. And so it's just an unbelievable amount of money, literally beyond human comprehension. And the country did it without batting an eye. They're now proposing a $4 trillion infrastructure package, again, imposing horrendous burdens on posterity. And we have an obligation to stand up to this. Wisconsin, again, has done that by signing on to a balanced budget amendment convention, but we need to go further than that. We need to impose further fiscal restraints on the federal government. Simple things that are supported by the American people, like imposing generally accepted accounting principles on the federal government. Believe it or not, if you sit down with the OMB, they will tell you that they use precisely no accounting principles. Literally, I've sat with senior members of the OMB and asked what accounting principles they use, and they say, well, we don't have any set of principles that guide our accounting. So in other words, we have fantasy accounting at the federal government. We can impose also taxation caps and spending caps through our resolution. And I think those are also important. We don't want to impose a balanced budget amendment on the federal government only to have them tax us out of existence here out in the states. Finally, we can impose scope and jurisdictional limits on the federal government. And I think this gets to the sweet spot of SJR 8 and why we're here today, really. The reason that we have people who like to stay in Washington, D.C. so long, and the reason we spend so much money in Washington, D.C. beyond our means is because we have given them too much power. And when I say we have given them too much power, I want to be very clear about who I mean when I say we. Primarily, I mean the Supreme Court of the United States of America. Our opponents will say that the Constitution of the United States is a beautiful and essentially perfect document and that we don't need to do anything to it. We just need to, quote unquote, enforce it. And I often ask which Constitution they're referring to when they say that. And I brought something with me today to show you what they're not referring to. They're referring to a pocket Constitution about 14 pages long. What I have in front of me, you can buy from the government publishing office for about $130. It's not the Constitution printed on gold leaf. It is the Constitution of the United States of America, the Centennial Edition from 2012, government publishing office, 2,738 pages, actually over 3,000 pages with the supplements that go to this. This contains every case ever issued by the United States Supreme Court to tell us what a 14-page Constitution means. It's outrageous, and it has fundamentally changed the nature of the American system of governance. As one small example, or I should say large example, and Senator Felskowski brought this up earlier, it has given power to the federal government far beyond the enumerated powers. The Commerce Clause expansion by the Supreme Court has allowed the creation of the Department of Education, the Department of Energy, the Department of Congress, the EPA, the DEA, the FDA, things that the federal government was never intended to be involved in. Specifically, going to the Department of Education, you can go back in our history and you can look at letters from Thomas Jefferson to William Henry Lee. Henry Lee asks Jefferson if he could get federal money for the University of Virginia, which he's founding. And Jefferson says, well, we can't do that because it's unconstitutional, essentially without an education amendment. I've read the amendments. You've probably read the amendments. There is no education amendment. The education amendment is contained here in this annotated Constitution created by the Supreme Court. There's a remedy that the founders gave to us that is the ultimate act of federalism. And that is that we in the states have the right to stand up against the federal government and say, enough is enough. We're going to put you back in the constitutional box. That's what we're asking you to do today with SJR 8. Today, over 30,380 people in the state of Wisconsin have signed a petition in support of SJR 8. They want the Wisconsin legislature to stand up and to become number 16 in the states out of the necessary 34 to call for a convention of states. The race is on, by the way. I just got notified by cell phone earlier, sitting here in the committee hearing, that West Virginia's Senate just passed their resolution on a voice vote and is headed over to the House. The people of this state overwhelmingly support you passing SJR 8. That is true in every district across the state. And we ask that you do so today, that you pass this out of committee. And I appreciate your time today, and I'd be happy to take questions.
Thank you for your testimony. Questions from the committee? Senator Felskowski.
When you said it would limit federal judiciary, are you talking about the Supreme Court?
It would be all of the federal judiciary is up for grabs, essentially the Supreme Court and the lower courts as created by Congress. Importantly, we can also limit the jurisdiction of the federal judiciary. And we could also limit the Supreme Court to 9 justices. There's been talk in Washington, D.C., pretty radical talk, in my opinion, these days, of packing the Supreme Court, of adding a bunch of justices. And we could impose a structural restraint on the federal government, limiting the Supreme Court to 9 justices only if we chose to do so.
And just a little bit of explanation I asked Senator Strobel. So none of this is in the resolution. Term limit, the limit of the terms, everything. That would all be decided at the convention. Is that correct? Could you just walk through the process?
Sure, that is correct. The founders intended the convention process to be deliberative. The way the process works is when 34 states aggregated call for convention, meaning that the convention calls are virtually the same, then a convention is called. Congress has a role, and the only role Congress has, as specified by the Constitution, is Congress names the time and place for the convention. And then their second role is they name the method of ratification. 2 are specified in the Constitution: ratification by state legislature, in other words, both houses here in your body, or by state ratifying convention. Interestingly, I hear some fear talk about state ratifying conventions. It's important to note it's not specified what that is in the Constitution. It's up to the state legislature to set what that is. Actually, a state legislature could say a state ratifying convention is the state legislature meeting in session. So once you get 34 states to call, then they gather in convention, what's called a general convention. General not meaning anything is up for discussion, meaning that things according to the call by the 34 states are up by convention. General meaning all 50 states can and likely will attend. Each state chooses a delegation. The state legislature, according to Federalist principles, will choose that delegation according to their own desires. And so you will send a delegation from here in Wisconsin. I'm often asked, well, how many will be in the delegation? Well, that's really up to you. But each state gets 1 vote. This is a convention of states, not a convention of delegates or a convention of populations. You'll send your delegation. The delegations will go to convention where and when it's called, and they will debate anything in these 3 subject matter areas. Likely they'll operate just like a legislature, break out into subcommittees and committees, and ultimately report back to the committee of the whole for vote on any proposed amendments. When any individual amendment or slate of amendments reaches a majority in the convention, then those can be to the states for ratification. Ratification requires ratification quarters of the states. It is a super majority. In fact, it is the highest bar in the system of U.S. governance. There is nothing higher than requiring 3/4 majority of the state legislatures to ratify an amendment. When it is ratified then by 38 states or 3/4 of states, it then becomes part of the United States Constitution. So that's the full summary of the process, Senator.
And just one more time for clarification, nothing can be discussed except for what is addressed in the resolution. Is that correct?
That is correct. So that becomes what the rules or the law or the boundaries of convention. And we know this because the convention, actually every state that calls for convention is passing the same resolution. They're agreeing in advance what the convention is. Anything that anyone would try to attempt to discuss that would be outside those bounds would be ruled non-germane and out of order in that convention.
And that would be one of the mechanisms to prevent what people are concerned about as far as the runaway.
That is correct. There are multiple mechanisms. One is just the actual call for convention that states are agreeing in advance. Number 2 is procedure at the convention and objections to anything that would be non-germane. Number 3 is it takes 26 states to get anything out of convention. Number 4, frankly, the ultimate protection against the idea of a runaway convention is that it takes 38 states to ratify. And that means, importantly, that it takes only 13 states or 1 house in each of 13 states to stop anything from being ratified. And one of the things that I hear very often, I'm a very strong proponent of Second Amendment rights, and I hear we're going to lose our Second Amendment in a convention like this. I can tell you today there are 15 states where you can carry a long gun openly in a state legislature. There are 24 states where you can actually carry a handgun in the legislature. This is one of those states. And if you were to go into those states and suggest that the repeal of the Second Amendment be taken up, I would say you ought to be carrying a handgun because you're probably going to get chased out of those legislatures by armed legislators. Today, roughly 80 to 85%, and this has been consistently polled for 30 years, favor some form of balanced budget amendment on the federal government. Most of the states are required to balance their budgets. The federal government is not, and this is the reason for $29 trillion in debt. And yet, the federal government will never impose a balanced budget amendment upon itself. Again, contrary to human nature, to limit your own power. Finally, today, 72% of the American public across the country, so that's a bipartisan number, say the federal government is too big and it does too many things. It's too disconnected from the American people. We may argue on a partisan basis about what should be done, what should the federal government do, what should it not do, how much money should be spent on one thing or another, but where we do not disagree as American people is we do not disagree on the idea government should do less and that those responsibilities should fall on the states. At the founding, there was a great debate between Hamilton and Jefferson, and most people are aware of this debate. Hamilton, the big government guy, Jefferson, the small government agrarian guy, and they argued about what was the proper size and scope of the government. Both of those founding fathers would be considered small government people today, and they did agree on one fundamental premise. They agreed in what they called exclusive spheres of authority. And that meant that it would be untenable, outrageous, uninhabitable for a country to possess two layers of legislative authority on the same subject. They actually believed that if the federal government could do something, had the power to do something under the Constitution, then states did not, and vice versa. They believed that if it was in the purview of a state, then the federal government should have no authority. Today, we have a multi-layered system. You have your own departments of energy and agriculture and protecting your environment. And the federal government has these things, making it impossible for the average person to navigate this quagmire of rules and regulations and laws. The question is, what do we do? We live in a very contentious time in American history. Seems like every issue is 50-50. Americans agree on almost nothing. Whoever ends up in charge of the houses and the presidency in Washington, D.C., 50% of the country approximately opposes, and vice versa. So what do we do about that? What is the cause and what do we do? I would argue, and I think this is borne out by circumstances, that the cause, the actual very cause of our strife in this country today is not politics per se, it's power. It's about a fundamental question. See, we argue about what Washington, D.C. should or should not do. What should be the policy on energy? What should be the policy on abortion? What should be the policy on education in our schools? And they love that argument in Washington, D.C. They all love it, both parties. And the reason they love it is because the underlying premise of that argument is that we should look to Washington, D.C. to tell us how to live our lives. The American people don't buy that premise. People in Kansas don't buy that premise. We've polled this nationally. Fully 2/3 of Americans nationally, this is on a state-by-state basis, say that it is time to call a convention of states and bring the power back to the states. And that's what we're asking you to do today. This particular resolution that we're asking you to vote on has 3 subject matter areas. It says that the convention may debate, 1, anything that imposes fiscal restraints on the federal government. That would include a balanced budget amendment. It would include maybe caps on taxation and spending. My favorite, it would include potentially imposing generally accepted accounting principles on the federal government. Most people don't realize this. Actually, the federal government uses no accounting principles. I've sat with officials at the Congressional Budget Office. They have no principles. They just decide how they want to account for things. So we need generally accepted accounting principles imposed. Number 2, it could discuss anything that would impose term limits on federal officials. Notice I didn't say Congress, I said federal officials, because the problem is broader. We all understand the problem nowadays of the deep state of bureaucrats who are unaccountable, unelected. And again, this is nonpartisan. These are people who get into positions of authority, who are making the rules and the regulations. They're serving as rulemaker, as judge and jury on the prosecution of regulations, and they're not accountable to the American people. They are not elected. So we can put term limits on Congress. Yes, 80 to 85% of Americans believe we should do that, but also on the bureaucrats, on staffers, and also on the judiciary. And I think all of those things are important. The third thing is anything that would impose scope, jurisdiction, or power restrictions on the federal government. This is where we get into enumerated powers. This is where we're trying to bring the power back to the states, the power back to Kansans. Kansans elect you because they trust you and they believe in you, regardless of your party. Polling shows overwhelmingly that state legislatures have favorable opinion ratings among their constituents, while Congress, they're kind of below coronavirus in their favorability ratings. It's absolutely incredible. So your constituents want you to have the power, and the founders gave you that power. They gave you an incredibly unique power. And when I say they gave you, I mean you in particular, you as state legislatures. They gave you the power to call a convention, to propose amendments, and to ratify those amendments. That actually makes you the most powerful people in the federal government. You don't learn this when you take office and you come and you get your orientation. They show you where the restrooms are, the cafeteria, maybe the legislative drafting office, the speaker's office. They don't tell you about your role in the federal government, that you have this unique power. And there's a reason they gave you that power. They gave you that power because you are them. You sit in the same the founders sat, and most of them sat in colonial legislatures, in early state legislatures under the Articles of Confederation. They sat on county boards and county councils. And it's not that they thought that people who sat in those bodies would be better human beings, they understood human nature. It's that they understood that you would actually live among your constituents, that you would be close to your constituents, and thus more accountable to your constituents. Coming into a legislature like this, as I do every single week, reminds me of that. That I can walk into your office and I can sit down with you, that I see your constituents in your offices with you, meeting with you, that they talk about meeting with you out in the field. That's not true for congressmen and women. It's not true for United States senators. They have unique access to you, and this is what the founders understood, and this is why they gave you the power. I want to address one thing with all due respect about the 2/3 rules here in Kansas. I will tell you, generally speaking, they are unconstitutional. And the courts have ruled on this multiple times. You will hear otherwise from opponents of using Article 5. But this is the #1 treatise on the law of Article 5 written by Professor Rob Natelson. And so I want to read just a couple of quotations from this book. On page 30, it says, at the state level, legislatures and electors have often adopted state constitutional rules, legislation, and interstate compacts to manipulate the amendment procedure. Yet in a long line of cases, the courts have rejected those efforts. They are unconstitutional. By the way, the list of cases takes up half a page. It starts in 1813 is the first one, and it goes all the way to 1984 cases. So this is established law and authority. Note, this principle, ordinary legislation may not alter the amendment process. That applies at every step of the process: state legislative, application, ratification, proposal, and mode of ratification. This has been recently litigated in Missouri under Calzone versus Richard. And actually in this book, the Kansas Constitution is mentioned. It says, it follows, and this is on page 39, in the Kansas Constitution, Article 2, Section 13, requiring a 2/3 vote of each entire house to apply or ratify, it's not enforceable. And the Kansas Attorney General so ruled in an opinion, Kansas Attorney General 1910 on December 4th, 2019. You have the authority, by simple majority, to pass this resolution, to join the 15 states that have already done so. There are 49 states that have filed the application. 30 states have passed it out of committee, 23 states out of one house or another, 15 states completely. This year, expect passage in between 5 and 10 states. We are going to have a convention of states, and we are going to limit the scope, power, and jurisdiction of the federal government, and we are going to return it to you. The question that Kansans are going to be asking, there are over 30,000 of them that have signed the petition here in Kansas, they're going to be asking, will Kansas stand and make its voice heard? Will the Kansas legislature represent the people of Kansas in saying, enough is enough with the federal government, we want to restrain their power, and we want you, the Kansas legislature, to have that power? I'm here live in Philadelphia at the Tomb of the Unknown Soldier. When you hear the phrase lives, fortunes, and sacred honor, these are the folks we should think of, those who anonymously gave their lives. Well, today you have a chance to volunteer. You need to volunteer for conventionofstates.com, the movement that's going to save the country. These folks are willing to step up and give everything. We need you to give just a little bit. Go to conventionofstates.com.